And now the next talk is from Dr. Pankaj Varshney. We invite him on the dais to speak on the value of consent in CPA court. We all take consents, and consent is valid or not valid. We should know about it, how to make it valid.
Good
So
morning,
over to
everybody.
Dr. Pankaj.
Supreme Court introduced Consumer Protection Act in medical services after the case of IMA versus VP Shanta and others on 13th November 1995, and new rules were added in 2021. We have to take precautions to avoid risk of litigations, and among this, consent is a part of documentation which is very important. Negligence is judged by the judges who are not trained in medical science, so they rely upon experts' opinion, reasonableness, and prudence. This has been explained by other speakers. What is consent? Consent is when two or more persons agree upon the same thing in the same sense. It should be voluntary, it should be free from coercion, fraud, undue influence, misrepresentation, and mistake. It is given by an adult. And who is an adult? He is above 18 years according to Indian Contracts Act and above 12 years as per IPC. Consent is a protection. It protects from civil and criminal liability, but it does not give total immunity if complication is due to negligence. It is a rescue to the doctors. It acts as evidence in courts. Denied consent should also be recorded. It should be recorded by the doctor, not by subordinate staff, in the same ink, and there should not be any cutting. There is no fixed format for consent. Usually doctors say that they don't have any time to write consent. If you don't have time now, then you spend your time and money in court. What are the types of consent? It is implied consent, which is from conduct, words, or the circumstances, also called tacit consent. Expressed when anything other than implied. It can be of two types, oral and written. Oral is for relatively minor examinations and treatments. Written is in simple language which patient can understand. There is no fixed format. It is also called explicit consent. Express written consent for all major diagnostic procedures, general anesthesia, surgical operations, intimate examinations, determining age, potency, and virginity, and all medico-legal cases. Usually patients allege that they did not understand the nature of medical procedure to which they gave consent, so the concept of informed consent has came into force. Informed consent is when doctor gives all relevant information of the disease and treatment to the patient in a language he can understand. It is about benefit of treatment, risks of the treatment, alternative treatments options, no treatment risk, and documentation with signatures of both patient, doctor, and witness. Consent should be procedure specific, not general consent. It should be in the same ink, no cutting, no overwriting, no abbreviations, exceptions being therapeutic privilege. Exceeding consent is a consent to a particular procedure. In exceptional cases, during operation, surgeon may cross limits to save life or organ of the patient. Proxy consent is from parents or close relatives of a child or mentally unsound or unconscious patient. Emergency consent is when in emergency there is no relative around, then a colleague must be consulted. Consent is not required in emergency, notifiable diseases, armed forces, new admissions to prisons, request by police. Now, who should be the witness to consent? Witness is the person who attests or testifies the fact and in front of judiciary. He should be ideally uninterested third party. He should attend the informed consent process, and he should be independent of the case, and should not be unfairly influenced by the people involved in consent. Can be a nurse not directly involved in the case. Types of witnesses: signature witness to a particular signature, witness to consent process, he attests fact that information. Now, about witness, I would like to tell something very important. Usually in our practice, we take the signatures of relative of the patient as a witness, which is highly dangerous for us. Because when a case goes to court, and you say that you have already explained all the things to the patient, and patient denies it, then the court will ask the witness what happened. And if witness is relative of the patient, he will surely follow what the patient is saying. He will not favor you. So witness should be an independent party, not related to the patient and not related to the treatment. Now, few important cases about consents. In Shantaben Patel versus Breach Candy Hospital, National Commission states that doctors have to take risks with informed consent. Every operation has inherent risk and cannot be controlled, which cannot be controlled or avoided. In Shyamlal versus Dr. O.P. Nayak, National Commission said that endophthalmitis is a known complication of cataract surgery when done under informed consent, and a surgeon who does not have endophthalmitis is the one who does not operate. In Dr. S.K. Junjanwala versus Dhanvantri Kumar, Supreme Court says that in this case, patient said that he gave consent to lap chole, but open surgery was done. But consent included lap to open, so complaint could not be maintained. In Samira Kohli versus Prabha Manchanda case in 2008, there was no consent written. But in court, it was asked from the relatives, what were you doing when the surgery was being done? They said we were sitting outside. What did you do the day after surgery? They were at home. So the case was operated with consent, though it was not returned due to technical mistake, but there was consent, so case was dismissed. Thank you. This is our Delhi Ophthalmological Society annual conference, dates 7th to 9th October 2022. I am being the executive member of DOS, so I invite you all.